Hi, everyone. Thank you so much for joining us on this webinar on a mock procedural hearing. My name is Sean Pereira from Shearman and Sterling, and I'll be moderating this event. Our event will be conducted in 3 parts. First, I'll give a brief introduction to the facts on which this mock hearing is based and to the speakers, both the counsel and the tribunal. Second, and this will be the lion's share of today's session, we will have the mock procedural hearing conducted by the tribunal, during which you will hear arguments from counsel for the claimant and counsel for the respondent. Third, we'll round off the session with a short panel discussion at which we'll discuss issues that were raised at the hearing and related to the conduct of this virtual session. On your Zoom panel, you'll see a little Q&A button. So please feel free to ask questions, direct them to the panelists, and we'll try and answer them during the course of the panel discussion. So first, let's start with the problem and the facts. We've set this problem to draw out some of the procedural issues that would arise from the circumstances that we find ourselves in. Okay, some of you might face some of these issues in fact, in the current cases that you're working on. The claimant is Royal Istana Construction Corporation, Iraq. The respondent is Nucleus Energy Corporation. The claimant engaged the respondent to build a nuclear power plant in Iraq, and construction is still ongoing. The claimant asserts that the plant had to be completed in June last year and has claimed damages for the late completion. The respondent, by contrast, disagrees. The respondent says that there was no set completion date, and the respondent also relies on the COVID-19 pandemic as an event of force majeure that relieves it from its performance of its obligations under the contract. To this end, the respondent is also seeking to rely on certificates issued by the China Council for Promotion of International Trade in support of its argument that a relevant force majeure event has occurred. No, so those are the facts on which the procedural hearing is based. Let's turn to the proceedings themselves. The proceedings have been bifurcated into a liability and a quantum phase. The tribunal and parties had a merits hearing on liability in early 2020, after which the factual record was closed. The parties and tribunal are scheduled to have a further merits hearing on quantum in July 2020, and they're scheduled to file their expert evidence on quantum in June, ahead of the hearing, together with their submissions on quantum. But because of the restrictions around the world and the COVID-19 pandemic, an in-person hearing in July is looking increasingly unlikely. So the parties disagree as to how the tribunal should conduct the proceedings going forward. And so the tribunal has convened a procedural hearing for parties to argue 4 issues. The first issue is whether the tribunal should defer the exchange of the expert reports that are due in June 2020. The second issue is whether the tribunal should retain the July 2020 hearing date and conduct the hearing over a virtual hearing or defer the hearing date to when an in-person hearing can be safely scheduled. The third issue is whether the parties' quantum experts should take into account the COVID-19 pandemic in their assessment of the damages payable as a consequence of the delay to the project. And the fourth and final issue is whether nucleus energy should be permitted to adduce the force majeure certificate issued by the China Council for promotion of international trade as further evidence for the purposes of the quantum phase of the proceedings. So those are the facts and those are the issues on which you will hear the arguments. Before I turn it over to the tribunal, let me first introduce our participants. As the presiding arbitrator, we have Mr. Michael Schneider from Lali. Hi, Michael.
Good morning. Good morning.
And as his co-arbitrators, we have Mohan Pillai from Pinsent Masons M. Pillai.
Hello, everyone. Good morning, good afternoon, depending on where you happen to be.
And Ms. Swee Im Tan from 39 Essex Chambers.
Good day, everybody.
Appearing as counsel for the claimant, we have Kate Apostolova from Freshfields.
Hello, everyone.
And Alistair Tan from Drew and Napier.
Hi, everyone.
And appearing as counsel for the respondent, we have Mr. Simon Elliott from Three Crowns.
Hello, everyone.
And Ms. Margaret Ling from Ellen and Gledhill.
Hi, everyone.
So there you have it. I will now hand it over to Mr. President, please.
Thank you, Sean. We are hereby, the tribunal welcomes everybody. I say good morning because virtually we are all in London. It's an early hour for the city lawyers in London, but we're all fresh and we're happy to welcome you here at this hearing. You know the tribunal from earlier hearings. On my left is Mr. Pillai. On my right is Ms. Tan. Welcome to the tribunal. And the other participants will circulate a list of attendees. We have appointed Mr. Sean Pereira as the tribunal secretary. He will pass around the list of participants so that we have a record of this procedural hearing. The hearing will also be sound recorded. Do the parties have any objections to the sound recording? I see
no objections from the claimant.
Thank you very much. Also the tribunal wishes to ensure transparency. That is why we have opened this hearing to the rest of the world. And we understand from the YSIAC that there is a large number of auditors who are listening to this hearing all over the world. Welcome to all of you. From the parties, is there any objection to this transparency that this hearing is conducted in public?
No objection from the claimant.
I am glad to hear that. Now, the program of this hearing, you have heard the background in the procedural order number 5 that has been circulated. We explained the purpose of this hearing as it has just been summarized by the secretary of the tribunal. We have divided the rather short period available for arguing this case to have the claimant start, and the tribunal decided to allocate 20 minutes to the claimant, and then followed by 20 minutes by the respondent, and then 5 minutes replies to both sides. Is that allocation of time acceptable to the parties?
Yes, from the claimant.
And the respondent?
Likewise.
Very well. Thank you very much. So after that, we will have deliberations of the tribunal, which again will be in the public. and we will hear from the transparent public that is attending the hearing, sitting in the background, the virtual background, any comments on this. Now, I will start with the claimant. The tribunal will leave it to the claimant's team to decide who will speak on behalf of the team. You have 2 members. Have you decided how you allocate the task? The claimant?
Yes. Yes, we have, Mr. President.
And the respondent?
Yes, we have.
Yeah, very well. So we leave it now to the claimant. The floor is yours.
Thank you, Mr. President. Members of the Tribunal, good morning. My name is Kate Apostolova, and I, together with my colleague Alistair Tan, represent the claimant, Royal Istana Construction Corporation, Iraq, in these proceedings. As directed by the Tribunal, today we will address 4 issues as outlined in Procedural Order number 5. I will address the Tribunal's first 2 questions, namely why the Tribunal should not defer the exchange of expert reports scheduled for June 2020, and why the Tribunal should retain the 12 July hearing date and conduct the hearing by videoconference. My colleague, Mr. Tan, will follow by addressing the 3rd and the 4th questions, namely why the parties' quantum experts should not take into account the COVID-19 pandemic in their assessment of damages, and why the respondent should not be permitted to adduce further evidence at this late stage in the proceedings. Turning to the first issue, the claimant's position is that the quantum phase of these proceedings should continue as scheduled. And this is so for the following 2 main reasons. First, and most critically, a deferral to the timeline would entail unwarranted and excessive delay in these proceedings, and thus prejudice our client's right to an efficient resolution of the dispute. There's no certainty as to when the pandemic would be over, and so this delay would be indefinite. There is simply no guarantee that the situation in all relevant countries for these proceedings will be any better in 6 months' time. This may be the state of affairs for a year or longer until a vaccine is developed. And there are even more concerns that it may get worse, that there may be a second peak or a second wave of cases. Thus, it is not feasible nor consistent with the overarching concern of the administration of justice and with our client's right to resolve the dispute as quickly and efficiently as possible to stop these proceedings for such a period. And indeed, deferring the timeline for the experts' reports indefinitely would go against the right to an expeditious resolution of the dispute required under the YSIAC arbitration rules, Rule 19.1. Second, contrary to the respondent's assertions, the lockdown restrictions do not in fact pose any impediment to the briefing and the preparation of the parties' experts. In its written submissions, the respondent has argued that it would be impaired in the briefing and the preparation of its expert because many of its project-related documents are located in Iraq and the UK. This argument is with no merit. The respondent is to be reminded that all project-related documents the experts are to use for their reports are already on the record, available electronically as exhibits. In both Procedural Order number 1 and Procedural Order number 5, the Tribunal emphasized that the expert submitted in the quantum phase, the expert report submitted in the quantum phase, are to be premised on the fact evidence and documents that are already on the record as at 5 February 2020, when the evidentiary hearing took place. Thus, the respondent would need no additional project-related documents from Iraq or the UK or any other country for the quantum phase of these proceedings. And even if it did, the respondent is capable of corresponding and transmitting the documents electronically and otherwise communicating virtually with its expert in preparation of his report. The respondent did so for purposes of its written submissions on the issues we are discussing today. The respondent did so when it consulted with its damages expert in Iraq on the effect of COVID-19 on his damages analysis, and it can continue to do so. And for these two reasons, the tribunal should retain the current schedule for the exchange of the expert report. Now, turning to the second issue, we submit that the tribunal should retain the 12 July hearing date and conduct the hearing by video conference. As a preliminary matter, we note that the tribunal has the power to order a virtual hearing in the face of an objecting party. Under the YSIAC arbitration rules 19 and 21.2, the tribunal is to conduct the arbitration in such manner as it considers appropriate, and it may hold hearings by any means it considers expedient and appropriate, including video conference. Under English law, the governing law of the contract, and the law of the seat, there's also no obstacles to holding arbitration hearings remote. And in fact, the English courts have endorsed and are themselves currently conducting virtual hearings and trials. Thus, under the relevant legal framework, the tribunal has broad procedural discretion to conduct the hearing via video conference. And we submit that here, the tribunal should do so for the following two main reasons. First, as already noted, a deferral of the hearing date would entail unwarranted and excessive delay in these proceedings, which would prejudice our client's right to an efficient resolution of the dispute. There is no way of telling when it will be possible to gather all the relevant parties for a physical hearing here. In this arbitration, we have people in several different countries, and while gathering and traveling restrictions are lifted in one country, this might not be necessarily the case for other countries. Second, nothing is lost by the conduct of a video conference hearing in this particular case. The subject matter and the nature of the quantum hearing is such that it can easily be conducted by a video conference. It is important to remember that at issue here is a one-day hearing on quantum, with technical issues that are capable of being resolved largely based on the documents. We're not talking about weeks-long hearing involving testimony from fact witnesses in multiple languages. In addition, the issues to be resolved are not many, and they're not complex. That is why the hearing has been scheduled for 1 day only, and it only involves one damages expert per side. Experience also shows that cross-examination or expert conferencing over video links is not more difficult or less effective than in-person cross-examination. In addition, a virtual hearing would preserve the parties' fundamental rights for equal treatment and the right to be heard. There are no due process or enforcement concerns with conducting a virtual hearing. Procedural fairness protects the parties' opportunity to present their case, and with a video conference hearing, both parties will have equal opportunity to present their case orally before the tribunal. There are also no known examples of arbitral awards being successfully challenged or set aside on the basis of the use of remote technology. In fact, the English courts have already rejected the argument that having a witness give evidence by video link creates an inherent procedural imbalance. An Australian court in 2016 also refused to set aside an arbitral award, even though it found there were numerous technical difficulties with cross-examination of several witnesses via video link during the arbitration hearing. The court noted that the mode of evidence by telephone or video conference does not produce real unfairness. And it also noted that with careful planning and organization, following best practices, these issues are typically avoidable. And in fact, postponing the hearing indefinitely until a date in which the parties and the tribunal and the expert can gather together is an objective breach of the parties' basic right for an efficient procedure. Because video conference hearings are a viable alternative to in-person hearings, the arbitration community has overwhelmingly embraced virtual hearings. They are described as the new normal, and there have been many successful remote hearings conducted to date. And in fact, YSIAC, the administering institution, has conducted virtual hearings, including, as reported by the Global Arbitration Review, a 1 week long hearing with participants joining from 3 continents and having 6 fact witnesses being cross-examined in different languages. The participants there remarked that the video conference operated without difficulty, and that the fact they were conducting a virtual hearing was almost forgotten as the matter went along. And with the tribunal stating that it would have no hesitation conducting more hearings in this format. And in fact, when confronted with objections over video conference hearings, tribunals and courts have also overwhelmingly rejected requests for delays. For example, just last month, the Federal Court of Australia addressed whether a 6-week trial, that's 6 weeks, not 6 days, involving 50 fact witnesses should be postponed, and the court dismissed the respondent's long list of objections to remote hearing, rejecting outright the idea that technological limitations and cross-examination of experts via video link would be unfair. And in fact, not only is nothing lost with a virtual hearing, but a lot is to be gained. 1, the tribunal will avoid undue delay. 2, there is an opportunity to reduce costs by avoiding the cost of traveling and hotel accommodations for the tribunal, the attorneys, the experts. 3, there's an opportunity to become part of the broader drive towards the increased use of technology to reduce costs and improve efficiency, as well as working towards a greener future for arbitration. And we all want to be part of that. And finally, just to note that the tribunal can avoid any logistical, security, and safety concerns with conducting a virtual hearing by adopting certain best practices and taking appropriate procedural measures concerning virtual hearings, which have proven effective, such as transmitting electronic bundles of documents beforehand, choosing a secure encrypted platform to conduct the hearing, and there are many good choices available, retaining additional technical support for the one-day hearing, run testing with all hearing participants and the equipment in advance of the hearing, and having backups in place in case of technological difficulties.
Ms. Absalova,
Yes,
I
Mr. President.
interrupt you. You mentioned a number of points that should be adopted. Do you recommend the tribunal adopt a certain protocol, as there are some have been issued already, or do you have any specific proposals apart from what you were just citing?
I think we can adopt a specific for this arbitration protocol, including technical protocol and guidance for expert cross-examination and conferencing as well. And the claimant would be happy to take the initiative in that regard.
Sorry to have interrupted you.
No problem at all, Mr. President. I'm left only to conclude that for the reasons I just stated, the claimant submits that the quantum phase should proceed as scheduled, and the tribunal should retain the 12th July hearing day for a virtual hearing. So if there are no further questions from the tribunal, my colleague, Mr. Tan, will address the 3rd and the 4th issue.
Thanks, Ms. Apostolova. I ask my colleagues, any questions from the tribunal?
Yes, I have a question, Mr. President. Ms. Apostolova, you've cited the duty under Rule 19 for the tribunal to conduct this hearing in an expeditious, economical way. One of the other obligations the tribunal has is, of course, to conduct it in a fair way as well. One of the points that we've noted in the procedural order is the respondent's position that there may be difficulties with witness conferencing for the experts. Would you like to address us on whether you see that as a problem and whether that is capable of being dealt with efficiently through a virtual hearing?
Yes, certainly. Thank you, Mr. Arbitrator. We don't see that as an issue. We believe that expert conferencing can be conducted just as easily via video link. And this is because expert conferencing includes a tribunal asking questions to the expert and the expert responding one after the other to the specific question. And if a particular expert has anything to add to what the other expert has said, they can use the raise your hand function or physically raise their hand and address the tribunal when their turn has been called. So we don't think that there is any issue with conducting an expert conferencing via video link.
Thank you.
Thank you very much.
Thank you. Now, anything else from the tribunal?
Can I just get some guidance here as to where the citations would be for the cases that were relied upon?
Yes. The English court case, which I cited to, is Hanaro Shipping versus Coffee Trading. The Australian case I cited to was Sino Dragon Trading versus Noble Resources International. And I'm happy to send the tribunal copy of those cases.
Yes, if you could, please. Thank you.
Most
And
definitely.
I suggest you add them to the record of the arbitration and discuss with the tribunal secretary the reference number to be given to it.
Certainly, Mr. President. Mr.
I understand now Mr. Han will address us.
Yes, Mr. President. Members of the tribunal, you've heard from my colleague, Ms. Apostolova, about why the video conferencing is definitely something that's feasible, and and why this is something that the tribunal should most definitely adopt for the purposes of the hearing coming up. And I just want to take this opportunity to set what the respondent is essentially asking for in context. It is clear from what they've said in their position in correspondence that their main objective here is simply to delay the conclusion of the proceedings and to delay the commencement and conclusion of the hearing on quantum. The tribunal should therefore be mindful that this is their main objective and should therefore reject the request. And I will not go into the two issues which tribunal has asked us to to submit on. The first one is the delay, whether the delay analysis should take into account the economic impact of the COVID-19 pandemic. Well, the short answer to this is no. We submit that the damages for delay must be calculated based on the evidence, which is already on record, which has closed. The tribunal will recall that in Procedural Order 1, paragraph 5, the tribunal had directed and parties had agreed that the factual record would close upon the conclusion of the evidentiary hearing on the 5th of February 2020, and that the expert evidence and written submissions submitted at the quantum phase would be premised on the fact evidence and documents that were already on the record as at 5th of February 2020. So that's the first point. The determination on quantum has to be based on the evidence which is already on the record, and that is something that the tribunal had directed the parties to do, and the parties had agreed upon. And what is more important here is that the COVID-19 pandemic did not happen last month or did not happen last week. It started late December. By early January 2020, the World Health Organization had made various announcements on this matter. And at that point in time, the merits hearing had yet to be concluded. The tribunal recalled that the merits hearing only concluded on the 5th of February 2020. However, even though the COVID-19 issue was already an issue back in January, no such matter was raised at the merits hearing, and certainly not after the merits hearing. It's only been raised now, 2 weeks before the written submissions and the expert reports are due to be filed. There's been no explanation from the respondent as to why it is only making this request now. And in any event, it is clear from their conduct so far and their agreement as reflected in Procedural Order 1 that there's been a clear waiver on their part to raise this COVID-19 pandemic as an issue, and certainly something that the experts should take into account when issuing their report. The request should therefore be rejected. I move on now to the second point, which is
before you,
yes,
Mr. Tan, before you move on, as you know, the works are going on and the delay is accumulating. How do you suggest that the tribunal should deal with the ongoing delay? Should that be reserved for a later claim, or should we deal with it in the award we will make after the quantum hearing? Just as a point general to counsel, we are coming up sometimes with questions that have not been rehearsed before. So if you wish to take time for considering these questions, you're free to do so, but we would be happy if you have an immediate answer, but don't feel pressed for that.
My suggestion, Mr. President and members of the tribunal, is that be dealt with together with the expert. If the tribunal has any issues, which the expert could be during the expert conference, this is something certainly that the experts can address based on the factual matrix which are already on record, Mr. President.
Mr. Tan, you have just suggested that we leave out from the remainder of the proceedings the impact of the COVID-19 pandemic. So we will have to make, after this hearing and prior to the expert hearing or the quantum hearing, we have to make a decision if we include it or not, and then it'll depend on that decision what will turn out in the end the scope of our award.
Yes, Mr. President. I think essentially the point I'm trying to make, Mr. President, is that the delay should be calculated on the basis of the expected consequences of the delay at the time the breach occurred, Mr. President. So essentially what happened after that is to some extent irrelevant. And that is why we submit that the COVID-19 pandemic, regardless of what the respondent is now trying to assert, it is something that is in any event not relevant to the issue at hand.
So in other words, the claimant was expected to have a crystal ball. Sorry, sorry, I see Ms. Han has a question.
Yes, Claimant, can you also confirm that in this situation, as I understand it, the damages are continuing?
Yes.
So how do you propose to deal with that? I mean, how do you quantify something that is still continuing?
Like I said earlier, Madam Arbitrator, we submit that it should basically be calculated from the date of breach, Madam Arbitrator. So whilst it is continuing, these are matters which are already on record when the issue of liability was heard, and all the facts which the tribunal requires to come to a decision on quantum would already be on the record, Your Honor, and the experts will be able to address that point with sufficient regard to the facts before the tribunal.
Okay, so you're really talking about predicting forward, the crystal ball that Mr. President was talking about. Okay, noted.
You'll pass on your crystal ball to the respondent also? No, I think we should share the crystal ball.
We have good experts, Mr. President, so I'm sure.
Very good.
The future.
Very good.
If I may move on to the second point, which is basically the application by the respondent to adduce further evidence, adduce fresh evidence in the form of the force majeure certificate. I'll make a couple points to this. First, as I've indicated earlier, there is no basis for them to now attempt to include fresh evidence as the record has closed, pursuant to the direction by the tribunal and the agreement of parties as reflected in Procedural Order 1. Now, whilst the tribunal, of course, has the discretion to allow fresh evidence to be adduced, and we recognize that, but we would submit that there are certain factors to be taken into account. And whilst we also appreciate that the tribunal is not bound by the rule in Ladd and Marshall with regard to the introduction of fresh evidence, we submit, members of the tribunal, that these are factors which the tribunal should take into account when determining the respondent's so-called application to adduce fresh evidence. And I would briefly go through these factors. First, the evidence is something which could not have been obtained with reasonable diligence during the hearing, and that the evidence, of course, must be important to influence the result of the case, and the evidence must be credible, something that presumably must be believed. Now, bearing those factors in mind.
Can I just ask a question about the case you cited, Ladd and Marshall? Is that case limited, you think, to circumstances where a prior tribunal has had to consider evidence come to a view, and a superior tribunal is then being asked to review that decision? Obviously, there are implications in terms of the evidence that was presented before the original tribunal. Circumstances here may appear to be somewhat different.
Yes, sir. I appreciate that. I don't think it's limited in that sense. But what the point I'm trying to make here is that in considering their request and in considering whether or not to allow this evidence to be admitted, so the so-called evidence admitted, tribunal should at least bear in mind these factors. And I briefly go through this. First, if we look at what they're trying to adduce, the alleged certificate is clearly a document which would have been available to the respondents prior to the hearing of the merits on liability. There is no explanation whatsoever as to why they're only seeking to adduce this evidence now. And also, it's unclear how this is relevant to the issue of quantum. The claimant is not bound by a certificate issued by a third party. The issue during the merit stage was the date on which the respondent should have completed the power plant, and whether or not it was obliged to do so by the 30th of June 2019. So this so-called certificate, which I presume the respondent wants to use as an excuse to explain why he was unable to obtain certain parts from its supplier, cannot by any stretch of the imagination be relevant to the issue. In any event,
Mr. Tan, you have struggled against some of your time being used by the tribunal, but that is part of the game. So we suggest that you come to wrap up, because as I said at the opening, the time is limited for both sides.
Thank you, Mr. President. Could I just 1 minute to wrap up then? Well, if I just wrap it up, at the end of the day, the failure to obtain parts from its supplier, failure by the respondent to obtain parts from its supplier, is not something that can be used to excuse its contractual obligations under the underlying contract in this arbitration. The certificate is therefore not relevant. And lastly, there's also the timing of this document. Coincidentally, it is again being raised 2 weeks before the submissions and expert reports are due to be filed, and about 6 weeks away from the actual hearing of the quantum hearing. So that there's been no explanation as to why these documents have only so-called surfaced now, and therefore the tribunal should approach this with great skepticism. And this, I would submit, calls into question the document's veracity and authenticity as well.
I think I'll cut you off there. I have a question from Ms. Tan.
Yes, please. Mr. Tan, what is your position with regards to the relevance of that certificate to the issue of quantum as opposed to one of liability? Perhaps I've missed something that you have said.
It is, well, Madam Arbitrator, without the, obviously, we take the position that it is also not relevant. If it's not relevant to the issue of liability, it is also not relevant to the issue of quantum. Because at the end of the day, the force majeure, well, rather, it would appear from what the respondent have set out in correspondence that this is being used to excuse it from performing its contractual obligations under the underlying contract. We say from the outset that that's not something that can be done, because its contractual arrangement with some other party should have no bearing on what it is obliged to do so under the underlying contract here.
Very well. Thank you for the claimant, for your argument. I turn now to the respondent. Mr. Elliott, Ms. Ling, how are you going to allocate your time?
Good day.
Minutes now.
Good day, members of the tribunal. I will deal with the first two issues. Mr. Elliott will deal with the next two issues, and we will split our time up equally.
And the tribunal will make an effort to control its questions, but you are not, you won't be spared. But bear in mind the time limits.
Thank you, Mr. Chairman. Honorable members of the tribunal, at the outset, we take umbrage at the suggestion that the respondent is trying to delay the proceedings. No particulars whatsoever have been provided by the respondent's counsel in this regard. In pushing for the original timelines to be adhered to, the claimant's counsel has only pointed to the fact or the risk that proceedings might be postponed indefinitely. But I think we can agree that most countries are in the process of easing their lockdown measures, and everyone is trying to get back to business as usual. In any event, the fundamental issue that needs to be addressed in this case is whether it is appropriate on the facts to make the directions sought. In our submission, we say that the facts justify an extension of time for the exchange of written submissions and expert reports, and that the substantive hearing should be delayed. And I'll just make three short points. First of all, it is a fundamental tenet of natural justice that each party be given a fair opportunity to present its case. A breach of natural justice risks the award being set aside or refused enforcement. Second, in considering what are the appropriate directions to be made in this case, we respectfully submit that all the facts need to be considered. These include the nature of the hearing or the proceedings before the tribunal. Second, whether there's any urgency in proceeding with the matter. Third, what are the consequences of COVID-19? Third, and the last point, we submit that in this case, the factors justify an extension of time and the deferment of the substantive hearing. First, it must be borne in mind that we're dealing with a hearing on the assessment of damages. This is not a straightforward procedural hearing, or let's say a hearing for interlocutory relief. The proceedings are likely to be fiercely fought and highly contested. The amounts in dispute are likely to be significant given the subject matter involved, i.e. the construction of a power plant in Iraq. Moreover, as my co-counsel will argue, we are intending to adduce further evidence to be put into the record. Second, we have project documents that are located in 3 different places: Iraq, UAE, and the UK. While documents may be transmitted electronically, I think the issue that needs to be addressed is whether we can get access, or whether our client can get access to those documents in the first place. For instance,
can I ask you to, in the context of the point you made, deal with the rebuttal by Ms. Apostolova that frankly the documents are already on the record, given that we've had the hearing some months ago. And this is leaving aside the leave that is being sought for some additional documents, but that's fairly limited. But she's made the point to the tribunal that all of the documents that are part of the factual record are already electronically available, and therefore the question of searching and looking for more documents is not something that really arises for the experts hearing that is going to be taking place and the exchange of the reports.
Thank you, Mr. Pillay. I believe that the expert may require further evidence or instructions in order to prepare his expert report. We are instructed that perhaps site surveys may be required. I think all these are matters which need to be fully ventilated and fully considered by the expert, again, bearing in mind the quantum and the subject matter in dispute. It is a significant dispute, and each party should be entitled and given the full opportunity to present its case.
Sorry, Ms. Lin, can I just interrupt you there? You talk about additional evidence that may be required, including site surveys. I mean, are you suggesting that these are additional evidence to that's already on the record? Because I don't see before us any application for additional evidence other than for that certificate from China.
I noted, Ms. Wee Im Tin. The expert might require further documents, in which case we would need access to those documents. It may be that we will take out a further application at a subsequent time to put in additional documents, but I take your point.
So I suggest we leave this point until you've made an application.
Noted. In that case, I'll move on to my two other points. First, just to recap, given the nature of the proceedings, this is not suitable for a matter to be held remotely by video conference. Secondly, no urgency has been shown by the claimant as to why the proceedings should proceed based on your original timelines. It is always open to the claimant or the tribunal as appropriate to award pre-award interest if necessary to compensate the claimant for any prejudice that may be caused by the delay. And third, we also raised the issue of whether it is logistically practicable for the hearing to go on, given that members of the tribunal and counsel are located in no less than 5 jurisdictions, while various guidance notes and practice notes have been issued regarding the use of technology in international arbitrations. They are predicated on members having certain minimum technological requirements. So for all these reasons, first, the nature of the hearing. Second, the feasibility.
Are you saying the tribunal is not IT savvy?
No, more like we need to, of course not, so we will not be suggesting that. But we raise concerns when it comes to our potentially witnesses, counsel, clients' representatives, given the number of participants involved and the fact that they are located in various jurisdictions. This is potentially a practical hurdle and an obstacle that might come into play. And we don't see why this, coupled with the fact that there is no urgency in the proceedings continuing, justifies the hearing proceeding based on its original timelines.
Ms. Lake, you mentioned the possibility of various counsel parties and so forth not having the technological capability to do everything online. There are no specifics before us, Ms. Lake.
That's right. I believe the Claimants Counsel has stated that she would come up with a list of requirements. At present, these are not fixed. We do not know what are the requirements that can be complied with or not. Based on personal experience, there have been technological hiccups when it comes to video conferencing. And again, I stress that because of the nature of the proceedings, given what is at stake, and given the fact that it might be factually contentious, yes, while the factual record is already before the tribunal, it can nonetheless raise factual issues. For instance, when could the project be completed in time? What are the damages that the claimant should be entitled to? Given all these matters, we say that it is preferable for the hearing to be deferred so that the claimant and the respondent have equal and full opportunity to present their case, especially given the fact that no concrete particulars or evidence have been put forward by the claimant regarding the prejudice that they would suffer if an extension were granted or if the hearing were deferred.
Ms. Lin, how long do you suggest that we should keep waiting? At some point or other, we've got to put a stop to this. And I mean, at what point do we wait? And at what point do we decide we go forward?
Perhaps I could suggest that another hearing or administrative hearing be convened in 1 month's time. I think most countries are easing their lockdown measures. In Iraq, at least, the 24-hour curfew will end on 3rd June. And I think perhaps you could have a hearing 2 weeks from then and then take things forward.
In fact, what are the precise lockdown, what are the lockdown requirements or lockdown rules in Iraq? Perhaps you can assist us.
Ms. Tan,
Yes.
Given the advancement of time, may I suggest that we leave the decision on this point, which arises only if we decide that we will defer, we will leave that for submissions after we, the tribunal, have decided whether the hearing should be deferred. Is that agreeable?
Fine. That's fine, thank you.
Very well. So, Ms. Ling, if you could advance in your argument and wrap up so that Mr. Elliott still has some time to the many points he was planning to present to us.
Thank you, Chairman. In short, we submit that the claimant would not suffer any prejudice if the extension of time in the proceedings were deferred. On the contrary, not granting extension or deferring the proceedings would result in prejudice to the respondent, who will not be able to present its case fully. That is all I have.
Well, on the savings, both sides was arguing, we would like to have at some stage an explanation or quantification of the savings if we perform the hearing virtually. I think it's that just the travel and the hotel costs or compared to the volume or the amount in dispute, it probably is a relatively small amount. But if both sides could at some stage quantify to us what is the financial impact of moving virtual. Now, I understand Mr. Elliott will continue.
Yes, sir.
Thank you, Mr. President, members of the Tribunal. So as my colleague Ms. Ling said, I'll be addressing you on the third and fourth issues, namely whether the parties' quantum experts should take into account the COVID-19 pandemic in their assessment of damages, and second, whether the respondent should be permitted to adduce additional evidence, namely the force majeure certificate that has been issued to its parts supplier in the People's Republic of China. Now, Counsel for the respondent has spoken very eloquently of the reasons why you should disregard the undeniable effects of the current COVID crisis on the quantum of Ritchie's damages, and a key element of its case on the date of breach, namely the availability of ready-made parts from China. Let us make no mistake about what the claimants are seeking to do. They are seeking to deny the respondent the procedural opportunity to put forward its defence, first of all, by insisting that the current schedule be maintained and the hearing be held by videoconference. On these two issues, it's seeking to impose substantive fetters on the respondent's ability to put forward its case by suppressing information and evidence that is relevant, highly relevant, to the quantum of any damages that might be payable. So I'd like to turn first to the first issue that I'm going to address. And I note that my friend seemed to conflate these two issues somewhat by transforming the first issue into a question of what is on the record and what can be added to it or not. In my submission, this first question really just goes to the relevance, the potential relevance of the COVID pandemic to the assessment of damages. And in my submission, there really can be no question that it is relevant, and that not only are you permitted to take account of information that postdates the date of breach, which is alleged to be the 30th of June 2019, but you must if you want to arrive at a fair assessment of the damages that could be payable. Now, my friend submitted that under English law, you are required to ignore the effects, to ignore information about events that postdate the date of breach. This is, with respect, not correct. It was perhaps once the case that English law required damages to be assessed only by reference to events that predate the breach. But the UK Supreme Court in the Bungie case has now very clearly put that debate to bed. Under English law, the fundamental principle, as you will all well know, is that so far as money can do it, the injured party is to be placed in the same situation as if the contract had been performed. In the Bungie case, the UK Supreme Court affirmed that fundamental principle in the context of considering whether or not an arbitrator was right to have taken into account effects that postdated the breach for the purpose of assessing damages. Now, we've spoken a little bit, or we've mentioned the proverbial crystal ball. And I'd like to remind us of all of what Lord Tolson said in that respect. So when considering whether the assessment of damages should be made on the facts as known at the date of the assessment, or should the tribunal apply a retrospective assessment of how the charges would have appeared at the date of repudiation, Lord Tolson said, "I see no virtue in such circumstances in the court attempting some form of retrospective assessment of prospective risk when the answer is known. To do so would run counter to the fundamental compensatory principle." He then referred to the Golden Victory in Lord Bingham's speech, where Lord Bingham acknowledged this point, saying that you need not gaze into the crystal ball when you can read the book. Now, these points will obviously be the subject of further debate at the quantum hearing if Nucleus is given the chance. But what is clear is that there is no legal blindfold that you must apply to put out of your mind the information that we now all know. Here, you can read the book, you need not gaze into the crystal ball. And in our submission, you should do that, you must do that. And there's certainly no basis for fettering Nucleus' ability to put forward its case on this point by directing that the quantum experts should not address the COVID pandemic and their assessment of damages. So I'd like to pass now on to the next issue, unless there are questions for the tribunal.
Can I ask you a point about what the order that you are seeking? If we should be minded to grant the order that the quantum experts can take into account the COVID-19 pandemic, does that oblige the tribunal in assessing the evidence to take that into account, or do your clients accept that the tribunal is at liberty when deciding the award to take a view on the weight, if any, to give to that evidence?
In our submissions, sir, you would need to take the evidence into account because it bears directly on the quantum of damages.
No, Mr. Elliott, the point I'm making is if we allow that evidence to come in, are we bound to give weight, or do we still have the flexibility as a tribunal to say we've heard the evidence, but we don't think that it goes in any way towards adding or subtracting from the damages? Or do you say that we are in fact bound, if we allow the evidence to come in, to take that evidence into account? We can't disregard it at any subsequent point in time.
I would say, sir, that if you admit the evidence, then you should have regard to it, but you're, of course, in your sovereign discretion, entitled to discount it and discount the fact that it has any impact on the quantum of the claimant's damages.
Both of you have been interrupted, but if you could move on quickly, because we are getting close to the end of your time. In fact, you're almost over.
So I'll finish quickly. On the next issue, first of all, I would like to register the respondent's very strong objection to the suggestion that was made by counsel for the respondent that the authenticity or veracity of the enforcement certificate that we seek to adduce is questionable. That is not the case, and there's no basis for making that suggestion. Turning to the relevance of the certificate itself to the damages assessment, despite what my friend said, it is of course relevant. It is of course relevant. And the UK Supreme Court in the Bungie case tells us that. In that case, the court confirmed the fact that the defaulting party may have been relieved of its performance obligations by an event of force majeure or an event of frustration after the date of breach is a relevant fact that may be taken into account. So there is no doubt as to its relevance. The question is whether you are able to admit the force majeure certificate, and we say that you are. Under the YSIAC rules in 19.1, you're given a very wide procedural discretion, and there is an emphasis in that provision, I would say, on your duty to conduct proceedings fairly. It is the first obligation that appears in that provision. Now, here we have a partial closure of the proceedings rather than closure prior to the drafting of the award is contemplated under the YSIAC rules. The closure that we have here is not expressly dealt with, but the provision in 32.1 of the rules that deals with the closure of proceedings makes clear that it's only really appropriate where the tribunal is confident that the parties have no further relevant and material evidence to adduce or submissions to make on facts that will be addressed in the award, that needed to be decided in the award. Now, Rule 32.2 gives the tribunal a wide discretion to reopen the proceedings. The rules don't impose any particular conditions on the exercise of that discretion, and the Secretariat's guide confirm that none exist. Now, in our submission, clearly, by analogy with the circumstances under which it's appropriate to close the proceedings.
I think that should be signed for you to wrap up. Mr. Elliott, that was a good sign.
So relevance and materiality is the touchstone. We say the certificate is relevant, it is material, and you should exercise your discretion to allow the respondents to adduce it. And with that, I will conclude and thank the tribunal.
Quick question, please. When exactly was that certificate made available?
That's a very good question, Ms. Tam. The date of that certificate is obscure on the facts that we have. So I think it's also a matter that needs to be investigated further. So I think it may have been a little bold of my friend to say it was clearly available at the time that the merits hearing was held.
Thank you.
Thank you very much. I think that completes the argument of both parties in the first round. Mr. Secretary, how much time do we have left and how do we organize the time that is left?
Well, Mr. President, I believe the parties are in agreement that they've decided to forego the rebuttals so that the tribunal will have more time for deliberation and there will be more time for the public, Mr. President, that you referred to scrutinize or audit these proceedings. Mr. President, with your permission, perhaps we'll draw these proceedings to a close and move to the panel discussion.
Thank you very much. I understand this has been consulted with the parties, and in fact their argument and in particular the response to the questions from the tribunal were so eloquent and showing that they're thinking on their feet, reacting very quickly to unexpected questions. We thank both parties for their enlightening argument, and I suggest that because of the limitation of time, before the tribunal deliberates, we hear whether there is any feedback from the worldwide audience that has listened to it. Is that agreeable, Mr. Secretary?
Yes, definitely. So for all of you who are watching this webinar, you'll see the Q&A button on your Zoom screen. So please, feel free to include any questions you have, and we will try to discuss them in the panel session. Well,
would that mean we let the public now put questions and we start deliberating?
Yes, exactly.
Okay.
Sorry. Go ahead, Mr. President.
So let's take the 4 points one by one. I turn to the first one. Should we preserve the hearing date and perform it electronically or virtually? What do my co-arbitrators think about this?
Well, if I can start there. I mean, I haven't heard anything very, very specific or concrete as to how and what the prejudice is. So far, what I've heard is that we have got the evidence that's before us that's already been closed, and that there is, apart from that force majeure certificate, there is no application before us for further documents to be adduced. So it sounds a little bit speculative to me, if you, in respect of the arguments about deferring it.
Mr. Pillay. Well, now that we are deliberating, I think we can move to first name basis as we normally are. But in the hearing, we say, Mr. Pillay, now you're one.
Yeah, Michael, I mean, I think one of the difficulties I am struggling with, and this is no fault of the parties, but really the result of the COVID-19 situation around which these applications are being made, is the date to which we are being asked to push this to. We are being asked to defer, but we have no end date in view. And Sui Im did present this particular difficulty to counsel, and the answer we got was, well, come back in a month and we'll see whether we are in a better position to assist the tribunal. And then that causes me some difficulty. I don't think that means we can't grant the order, but it does suggest that we would need to be fairly compellingly convinced that there is sufficient justification for an indefinite postponement of the timelines that we have asked the parties to abide by.
One, it's a very good point. And in fact, if we travel now to London, we'll all end up in quarantine. And perhaps we could conduct a hearing in quarantine.
Yeah, can I also add, actually, Michael, that in terms of the possible prejudice that's being discussed here in terms of holding the hearing, it's not something that is clear. So my point is that we could actually start, and if indeed there are certain issues or certain areas that truly require physical hearings, I mean, it's something that we can consider. But I haven't really heard anything specific right now to even stop us even trying doing an online hearing.
And in
We're
fact,
not cast in stone whether it's yes or no. I mean, we can actually start off with it and like I said, just defer certain things if need be.
And in fact, the counsel have shown very well that at least the argument can be done perfectly online in a virtual hearing. It may be a bit different if you have the two experts and exchange, especially something that hasn't really been discussed, how you handle documents, especially in a quantum hearing. That may be a bit of a complication. Now, perhaps I turn to Mr. Secretary. Have there been any questions on this issue from the audience?
Yes, thank you, Mr. President. There has in fact been a question, and it's a nice point because it touches exactly on the considerations that you've been deliberating about. And the question is this: what is the value of legal precedent in procedural matters where COVID is involved? Will these be fact-heavy, considering the tribunal's general discretion, or does court practice have value? And I suppose this is a kind of passing reference to the cases that Kate cited, the Hanaro shipping case and the Sino-Dragon trading case. So perhaps we'll direct that question to the tribunal. What are your views on the relevance of legal precedent and court practice on these issues?
I think before we discuss this, we have to see what type of precedent it is. Is it precedent to arbitration or precedent to court proceedings? And I would say precedent to court proceedings binds the courts and not necessarily the arbitral tribunals. But of course, the cases were quoted to show that a hearing can be conducted without any loss of fairness, and that would be similar in court and arbitral proceedings. Are there any views of my co-arbitrators?
My sense is that, when you're dealing with substantive points of law, and in an arbitration where the choice of law is of a particular jurisdiction, in this case, England, we would certainly expect some guidance as to what the law is and then apply that law. And I think in that context, court decisions of England, because it's a common law jurisdiction, is of some relevance. I think it is far less relevant when you're dealing with procedure. And the issues that we are dealing with are primarily procedural. It's a question of fairness. It's a question of whether we are going to be able to ensure that each party has an opportunity to properly present their case. And in those circumstances, while some of these cases are helpful, I think they would weigh far less heavily on me in the decision that I would be looking to make, because that would be entirely dependent on how we would manage the facts that are relevant to the parties that are appearing before us.
Mohan, I fully agree with your distinction, but in both cases it would be law. It's the law of civil procedure and the law of arbitration procedure. So if we look to this issue, we would have to look to cases that deal with arbitration procedure and not with court procedure. Sri?
I would also add that I think that the precedents have got value insofar as they give us guidelines as to benchmarks as to what would be considered to be discharge of natural justice and what doesn't. But obviously they remain as guidelines and it remains fact dependent.
And arbitrators have a greater degree of flexibility in organizing the procedure than the courts have. Mr. Secretary, are there any other questions that we should address immediately, so that we can see how to organize the remainder of this session?
Yes, Mr. President. So there's been a broader question about what you think about the benefits and disadvantages of virtual hearings are. So what are your views on this? I mean, the tribunal is extremely experienced. They've sat on many physical hearings. What are your views on some of the advantages and disadvantages? And there's a specific question that has come in on how you would take steps to prevent influence of parties from influencing the witnesses in the event that there's a virtual hearing.
Who volunteers to start? Is that one?
I'm happy to start, Michael.
Okay.
Right. I think there is, to some extent, an unfair, because I don't think people interrogate the preference very often. There is a preference to see witnesses and deal with evidence at the merits hearing in person. But I think that is more because of the conventional predisposition rather than, I think, the result of conscious choice. I think what's happened as a result of the COVID-19 lockdowns that we are all experiencing in various forms across the globe is that we've been forced to confront the question of whether we actually need physical interaction to be able to discharge a lot of the responsibilities. And, frankly, as I suspect with many others, I've come to re-examine many of the assumptions that I have made. And for arbitrators, it is very, very common for almost all of the preliminary meetings, even interlocutory applications, to be done on a virtual basis. Certainly in the case of international arbitration. So you do raise the question then of why at the merits hearing do we force everyone to troop in from all over the world? And just take a look at the nationalities we have at this hearing. We've got New York, we've got Paris, we've got Switzerland, we've got Singapore. Just think about the cost that it would take to fly everybody in for a hearing. So I think that there are significant cost benefits. The key concern for me would be to ensure that when the witness is giving evidence, there are sufficient safeguards to deal with the very point that Sean flagged up in the question. How do we ensure the integrity of the evidence? How do we ensure that when the witness is giving evidence, a panel doesn't appear on the right side of the screen where he's having a chat with someone who is guiding his evidence or her evidence along? And I think there are sufficient protocols and sufficient guidance in place that will go significantly towards addressing that. And I do think we need to re-examine the conventional assumptions that we have made that the merits hearing is one that has to be in person.
Can I add to that? I believe that it's completely true that it's just a question of perception and what we can and will not do. I mean, how many of us would have thought about having drinks with friends over Zoom? But we do. And actually, what I'm finding is that in a virtual hearing, your sense of focus is very, very strong because you're staring at the screen the whole time. There isn't a question of sort of wandering off somewhere, or your mind wandering off somewhere. Even your witness tends to be very, very focused on the screen. And this actually gives us, in a sense, it's better. You know, and in terms of documents, it's in the screen, it's there, it's in your face. So these are some of the benefits that I would say for virtual hearings. This hearing would never have occurred today if not for virtual hearings. And yet we managed to deal with quite a number of things. And I come back again to the comment that I made earlier on, which is that even if you can't deal with every single thing, you can certainly dispose of a lot of things. And that surely must be a benefit. I do agree that nowadays there are protocols as well, so we can deal with those.
Sri, I agree, especially procedural hearings like the one we had today, and I had others. I don't have much of a problem as long as it is simply talking heads on the screen. That is something where I don't miss much. I would say in a hearing where you have an interaction between the tribunal, counsel, and the experts, it is a very different atmosphere than what we're having now. That goes for experts, especially you have different personalities of experts who interact, and this interaction between the tribunal, the experts, and counsel is something that is lost. And to be frank, I'm not a great fan of the way how witness questioning is done. Generally with the witness statement and then cross-examination, you don't really get much of what the witness really wants to tell you. But one of the most exciting parts of cross-examination is that you have in front of you a person that distrusts you, and you try to establish a relationship with that person, and you do it before an audience, the tribunal, and you feel it like you're on stage. You feel what is going on. I think that's being lost. And I think this element, especially with taking evidence, is something that is being lost. I'm not so much concerned with fiddling behind the scenes. I mean, I've had witnesses being questioned on screen. I normally do collective questioning. I had once 3 witnesses sitting in Istanbul while we were sitting in Bishkek in Kyrgyzstan. I think that works, but you're really losing something important. But I think Sriyan is right in saying we'll have to measure what we lose and where this interaction really matters. I think for trying to understand the facts from physical persons, I would still have a preference of having these persons in front of me, and also feeling beside me the two co-arbitrators, and passing papers, or feeling whether they're with me, or the co-arbitrator feels whether or counts for counsel to see whether the tribunal is with you. I think for these there is still a difference, but perhaps as we advance, we manage to develop the skill of having this interaction and this feeling even on the screen. As we said, we're having toasts and cocktail parties over Zoom. So perhaps we're developing new skills.
Can I just add, I think you've raised quite an important distinction. I think as tribunal, there is a certain perspective one takes, which I think makes virtual hearings a little bit more manageable. And you've raised some very valid points about circumstances in which a physical hearing has clearly got advantages. But I think when you are counsel, virtual hearings present a real challenge in terms of reading your tribunal. seeing whether the point that you are making is one which the tribunal understands, whether you need to pursue that point with the tribunal a little bit more. Those kind of judgments are much easier to make. I mean, certainly when I appear as counsel, I do look at the body language of the tribunal.
Yeah.
I do want to make sure that the tribunal is not confused, doesn't require me to spend more time, isn't flipping through pages to locate the document, because I would then stop and ensure that the tribunal has all of the information it needs. That's not often easy to do at a virtual hearing. So I think perspectives can be a little different when you ask this question of a tribunal from a perspective of someone when you ask them as counsel.
That's a very good point. Mr. Secretary, may I suggest whether we have any feedback on that point from counsel? They've gone through the exercise. Did they suffer from the point Mohan just made?
Yes, so thank you, Michael. And you know, we're running low on time. So maybe I was going to suggest that perhaps we wrap up with this, with a final discussion for all of the viewers out there, right? Mm-hmm. What are some tips that you would give to those viewers out there who are, you know, facing up or preparing for a virtual hearing? What would you tell them that they should, you know, practical tips they should take note of? Maybe we'll hear from the tribunal, and you know, if counsel you've got anything to say, that would be great as well, and then we can round off the session.
May I just suggest to invert the order? We on the tribunal have talked a lot. Can we get some feedback from counsel? How did they expect, especially the point that Mohan made? Did they feel they had the same interaction with the tribunal as they would have in a hearing, in a physical hearing?
I agree. And I think for procedural matters, it's much easier. But when it comes to the actual evidentiary hearing, where you want to, where it's more important for you to read the body language of the witness and the tribunal, then that presents more of a challenge. But I think the reality is that virtual hearings are here to stay, obviously conducting one over Zoom is quite different from what we have in Maxwell chambers, where they use their proprietary software. So those are much more sophisticated and much clearer. So I think the issues to face there is slightly lesser. But I think to Sean's point on how to...
Sorry, Alistair, just on that point, I think that's very important for the participants, because you often have to choose what technology to use. Now, the technology you are recommending, what do we gain by using some different technology?
Well, I'm not recommending it per se, but I think...
No, it's not a particular, don't give any names, but the question is, what have we lost today by Zoom, which we would gain with a different technology?
Well, I think for one, it's the screen size is one thing. Watching it from a computer and what you have in Maxwell chamber is okay on a big TV screen, and I think the position of the cameras are slightly different as well. So you do get a much more personal feel, so to say. There were no technical issues today, but you can never avoid a situation in an actual hearing where you have technical issues, or where a witness suddenly just either intentionally or unintentionally cannot be heard. And I think when we that's the reason why we have to pay so much for these type of services, and they are worth the money to some extent, rather than trying to do it over Zoom or to do it over video conference.
I do agree that if you are going to take this forward, that hardware plays a part in it. And I would suggest also the other thing is not to use a virtual background like we are, because I think you do lose something by using virtual backgrounds. So these are...
You want my library background?
Yes, please.
Come and join me in Switzerland.
I would love to. Yes.
Now, any other comments from counsel? No. So, Sean, you want us to wrap up, or was that enough wrapping up? We have overstepped the limit.
maybe we'll go for a final round of any views from the tribunal on practical tips, and if not, we can draw the session to a close.
Any practical tips? I see, Swede.
Yeah, I think that, well, first thing we have to do is actually, one of the issues, of course, is consent to hold the hearings virtually. And if there is no, that really ought to be recorded, and let's not forget to do that. Obviously, if there is no agreement on it and there has to be a direction, then, you know, that's something that we have to record and put down on paper quite carefully. The other one, I think, is actually preparation. The amount of preparation outside of the hearing that is required to hold a virtual hearing, I think, is actually much, much more, because you have to be so much more careful and so much more organized. I have had hearings whereby experts, for example, have rushed through some sort of expert report, but they've managed to redeem themselves by coming into the hearing and taking over the whiteboard and being able to explain things very, very well on the whiteboard, which would not have come across in the
Why
expert
would that
report.
not be possible on a virtual hearing?
I think that nowadays, if you're going to have a virtual hearing, every single person that is counsel, witnesses, as well as tribunal are going to have to be much more well-read into all the documents than if you were in a physical hearing. And I believe that
Sweet, just to pick up this particular point, Sweet, you have these experts who go to a board and make the graphic designs. Would that not be possible in a virtual hearing?
Yes, it is. I'm just saying that it's not as effective. Therefore, they have to have their expert reports, I think, in a much more comprehensive and well set up manner. All I'm saying is basically now there's a lot more stuff that you have to prepare beforehand, even for counsel and witnesses, as to how you're going to present in your screen sharing. Because if you're very, very organized with this, I believe that you can convey your message and convey your case much better than if you were scrambling. So that's
but that goes for physical meetings too. When you're scrambling, the effect of your argument is less persuasive, I would say.
Of course, I'm just saying that it becomes worse. It just becomes worse virtually.
You think so? You think so?
Thank you, Ian. Michael, Michael or Mohan, any concluding remarks?
No,
What?
I mean, I just had 2 points I wanted to make. One is that, you know, you really need to pick your horses for your causes. There are certain types of hearings which I think lend themselves quite easily to virtual hearings. Things like, you know, procedural matters, your preliminary hearings, and so on. I mean, if you've got a hearing which requires a physical demonstration or models being presented in one shape or form, you obviously have to take a call on whether that is something that is really going to be sensible. But that goes towards preparation. And when you've got a virtual screen that you're watching, and, you know, if you are looking and picking up documents that loses the track and the attention of your tribunal, I think it is much harder to regain the attention of your tribunal at a virtual hearing if you are not really focused on the tribunal and you've got everything to hand. So it does require a bit more preparation. The second thing is you've got to get your technology right. In the lead up to this event, for example, you know, we had a number of dry runs just making sure the technology worked. So when I'm counsel in a matter and I'm going to be doing a virtual hearing, one of the key things you want to avoid is a technological disruption in the course of your hearing. So it does pay to make sure you get your research done, set up a couple of dry runs, make sure that you coordinate with the PA of the tribunal members and counsel on the other side, that everyone is happy and comfortable with the technology, so that when the hearing starts, you're not distracted by having the tribunal take a look at various icons on the screen to make sure that they can see what you want them to see.
I think, Mohan, these are very good. That is very good advice, especially the question of demonstrative. We had the debate in the context of site visits that do a lot of construction work and find site visits particularly exciting. In fact, they compensate a bit for the hard work on the construction cases, provided the site is in an interesting place. But it makes a big difference whether you have the site virtual or you're physically there. in the tunnel, in the structure. These are things that you can't really replace virtually. But otherwise, perhaps my conclusion on this is, as we go on, we may develop some of the sensitivity which we have in physical interaction, develop it in virtual interaction. I'm not fully persuaded yet that all of that can be developed, but I feel it myself. I'm progressing in this interaction, and perhaps others do. So I congratulate the organizers of this webinar for having given us the opportunity, to all participants and to those out there, to progress in the understanding and in the development of the judgment and sensitivity, which is essential for international arbitration. So thank you very much. Thanks to the colleagues on the tribunal. Thanks to the excellent and well-prepared argument from both sides, and especially thanks to Sean for having prepared this very well, and thanks to our host at YSIAC.
Thank you very much, Michael, and thank you to all the viewers out there who've tuned in and given us your time. All of us really appreciate it, and we really enjoyed ourselves. And I hope that for all of you, you found it as engaging as we all did.
Cheers to the party to which Sui is now going.
Okay, see you.
Thank you,
Bye-bye,
everyone.
Thank you.
Bye.
Bye.